Five. Welcome, folks. This is House Corrections and Institutions Committee. It is Thursday, April 2nd. And we are going through background information in terms of the world of forensics and what it means, how it plays out in different ways. And this is a way for us to become educated in that world, because when there's a proposal for a forensic facility to be housed in a Department of Corrections facility, there's a lot of implications in that. So I just want time with our budget council to have a real back and forth conversation so we can, as a committee, understand what we're dealing with in the world of forensic. So welcome, Eric.
Thank you very much. Eric Fitzpatrick with the Office of Legislative Counsel. Nice to see everybody this afternoon. As the chair said, here to talk a little background on the forensic facility bill that is, I think, passed third in Senate yesterday. So is on its way here, if it's not here already, but certainly
It's here next week.
right. Well, it's on the near horizon then. I think it's one of those issues that is complicated, probably more so legally, but also in my area of expertise is certainly not medical, but there's a medical component of it too that I think you're going to hear from witnesses about. But and interestingly, that's in some definitions, the word forensic is defined in several different ways depending on the context, but one of them is sort of this intersection between medical issues and criminal justice issues. It's kind of this intersection where they meet. And just thought it was interesting to hear. I pulled a couple of legal definitions, or actually just Oxford and Cambridge definitions of forensics relating to scientific methods of solving crimes, including examining the objects or substances that are involved in crime, denoting the application of scientific methods and techniques to the investigation of crime. They're sort of similar. That kind of gives you a flavor of it. And then I also pulled it, just since we haven't not looking at the bill quite yet, but I thought, well, I wonder what other state statutes say about forensic facilities. So I pulled Florida's forensic facility, a separate and secure facility established within the department or using department funding to serve clients who have been found not guilty by reason of insanity or incompetent to stand trial.
Which department is that?
That in Florida was the Department of Department of Children and Families. Interesting. It's in this department.
Yeah, he said
Yeah.
just, but it's not just for juveniles then.
Oh, interesting. The next sentence says, no, it's not, because the next sentence after the one of defining department as Department of Children and Families, the department is responsible for the treatment of forensic clients who have been determined incompetent to proceed due to mental illness or who have been acquitted of a felony by reason of insanity. So maybe there's some cross jurisdiction there, because that's not limited to juveniles, based on what I maybe for some reason that department in Florida deals with that population. But the term, nevertheless, is right on point to the bill that's going to be coming this way. And it's sort of, I think, almost the first question that often comes to people's mind when I bring that up is, well, what happens to those folks now? Those incompetent to stand trial or not guilty by reason of insanity? Or, well, let me just say that's what I want to describe as kind of our foundation. What happens now to this population that you are about to spend a lot of time thinking about how they should be treated going forward? And that sort of coincides with another population who aren't forensic. Yeah.
Is there anyone waiting to come into our Zoom room for Connor Casey?
I'll send him a quick text.
The Zoom link this morning, do we have the same? We have the same Zoom. Yeah. So you may, I'm sorry.
No problem.
Remembered. You're sending him a text, Troy?
Yeah.
So you may have somebody, Connor Casey. I'm sorry.
So one of the most significant differences and is most interested for this committee, I'm sure, is that right now, people in that population are treated by the Department of Mental Health. In the forensic bill, the portion of the population that it deals with is treated by the Department of Corrections. So that's one of the top 2 or 3 policy matters that is a central part of the forensic facility bill, and which would be a change from current law. Because right now, a forensic facility does not exist. So this proposes to create one, and it's proposed to create one. It tasks the Department of Corrections with creating it. So let's think for a minute about what does happen right now. Let's say that you have someone who was found either not guilty by reason of insanity or incompetent to stand trial. And keep in mind for a moment, because this will be helpful down the road, if you remember that those are 2 different things. Competency to stand trial and not guilty by reason of insanity are not the same.
So it might be good to go through that, because this is new.
Yes.
Some folks here, the difference.
Right.
Absolutely, because I don't know the difference.
It's a big difference.
There is. And one of the fundamental difference is that they both involve the mental health status of a criminal defendant. They have that in common. What's different is the moment in time at which you're asking, what is the mental health status of the defendant? Not guilty by reason of insanity has to deal with the defendant's mental health status at the time of the criminal offense. At that moment. And if at that moment, the defendant either cannot understand that their conduct is criminal, or they can't conform their conduct to the requirements of the law. So in other words, even if maybe they could understand that their conduct was criminal, they still lack the ability because of a mental illness or another mental health condition to adapt, to conform their conduct to what the law requires. Either one of those 2 things happens, then in legal terms, you cannot have the required mindset to create a criminal offense, to commit a criminal offense, because you lacked the mental health ability to form criminal intent. So when that happens, the person may, and typically does, concede that the criminal conduct happened, but they can't raise not guilty by reason of insanity as a defense. And if the defense is successful, then they are not convicted of the crime, even though they committed whatever the underlying conduct was, because they didn't have the right mental intent. And also, sort of a legal consequence of that, not guilty by reason of insanity is a complete defense. In other words, you can't be tried for that again. You can't regain that mental health status because it all had to do with what happened at that moment in time. And if you weren't able to understand that what you're doing was criminal, or unable to conform your conduct at that time, then that's never going to change. That was a moment in the past. And therefore, you can't ever be convicted of that crime. It's done. Very different than competency to stand trial. That has to do with what's your mental state at the time that the trial is going to be taking place. And that has to do with whether or not the defendant can understand the nature of the criminal charges against them, or they can adequately participate in their own defense. That is a different thing, because that you might still have had the correct mental intent at the time of the offense. If you're unable to understand the nature of the charges against you at the time of the trial, that's a fluid concept. So, in other words, it's as you will see, we'll be talking about a lot in the next few weeks. Competency can be restored. It's different than not guilty by reason of insanity. That was that one moment in time. If you didn't have it, complete defense, you can never be charged with it again. Competency, on the other hand, through treatment or time or whatever it might be, your competency could be restored. And if your competency, even if you are found at one point in time not competent to stand trial, that can be restored. And when that happens, the criminal charges can be continued against you.
So, questions? Complicated is that?
And
I assume you're going to walk us through currently who, what, when, and how the process.
Yeah, exactly, exactly.
So, the competency issue is one bar, and the insanity issue is the other bar.
Yeah.
And they're very different.
Mm-hmm.
You really have to understand that difference. And someone can gain competency back and they can have it for maybe a day. And
It can come and go.
it
It's
can
true.
come and go, but the
Yeah.
question is, competent to stand trial means they've been charged. And when would they be able to go to trial and understand what is happening to them?
Right.
That's what it really means, to understand the process and understand what's happening to them.
And you'll see, once you look at the bill, that those two different populations, so I don't have to say the long phrase every time as it happens, not guilty by reason of insanity has an acronym NGRI. So NGRI is what you often see it referred to as, the NGRI defendants. But those two populations, the NGRI and the competency, they both are proposed to be treated at this new forensic facility, but the treatments and the processes are different because they're different circumstances. Remember, because there's one population which through treatment can then go back and have their criminal trial because their competency can be restored, right? That's that population. So while they're at the facility, kind of getting ahead of myself, but it is nice to sort of have that foundation, which is that while at the facility, they are going to be receiving what's known as competency restoration services while they're there. That's the idea. And the idea is that while those services are going on, they may have their competency restored and then they can go back and their criminal trial can proceed.
So those services are basically medical services and therapeutic services. They're not security services.
I think they're clinical.
They're clinical services. That mindful. They're clinical services.
I mean, you've said that there are different parts of this. You're not going to go in depth about the medical stuff. Are we going to talk at all today about the intersection of that issue, whether these folks are overseen by DMH or DOC? No, park that. I'm parking that.
Yeah, we just want to know the basics right now, where they go now and what the process is when someone does retain competency, or if they are deemed not guilty by reason of insanity and GRI, what happens currently, kind of figure all that out.
Well, I guess then, yeah, can we discuss within the current context how those two different groups are treated within the facilities where they're housed now? Is that it today, or is that also a park it?
Well, as far as how they're treated within DMH, I don't have a huge amount of knowledge about that. I think it's going to be DMH folks, and Katie McQuinn in our office has some more knowledge about that.
Okay.
I can describe generally what the different results are for these
Okay.
two populations,
Sure.
and how it may
Yep.
pan out clinically, and what sort of their treatment programs are like, and that I have less knowledge about. Right. So step back again for a moment and let's think about, all right, what's the situation now, currently, without whatever is proposed to be an S-193? You have DMH custody and treatment, and there's actually, when we talk about people that are incompetent to stand trial or not guilty by reason of insanity, let's refer for a moment, because I was just saying that's more related to the criminal justice system, right? So let's refer to them as the forensic population. That's a forensic population that that's one pathway into DMH custody. There's another pathway that has nothing to do with the criminal justice system. That's comes through the family division of the Superior Court. And that is another pathway into DMH custody. And those folks are people who can be described similarly. They have been found by a court to be dangerous to themselves or others as a result of a mental illness. And that's a crucial.
Committed a crime.
I'm not. Nope.
It could be a family member,
Could be a family member, could be a doctor, could
could be
be,
one of us.
yeah, And it's interesting, there is a definition, and I'm not sure what it is. I think it's interested party. An interested party can file, although I almost think that there's a bill this year that changed that, right? I noticed that I was like, oh, I hadn't been involved in the bill itself, but I think I heard Katie or somebody talking about it because it has, and currently it's very broad. I don't think it's not passed and been signed yet, I don't think. So, but it's percolating. But nevertheless, the point is, as you were saying, Representative Emmons, it's not a crime. It's somebody, some interested person, medical person. I think actually now that I'm remembering correctly, it has to be a medical person going forward. That's the change. Could have been a family member or something in the past, but they go to the family division and they can file this petition. And there's evaluations, there's psychiatric evaluations, there's hearings that have to take place. There's specific time limits about how these hearings have to occur. And there's a finding that the court has to make. And that finding, either that the person is or is not what's known as a person in need of treatment. And that is defined as the way I just said it. A person in need of treatment is someone who, as a result of a mental illness, is a danger to themselves or others. That's the gist of it. And there's more verbiage to that, but that's the essence of the principle. They're, because of a mental illness, dangerous to themselves or others.
So the court determines that.
Correct.
So where does the person go? Because it's an involuntary placement.
It is.
It's not voluntary. It is an involuntary placement that is ordered by the court.
Correct.
It's a civil, not a criminal, civil proceeding,
Yeah. In the family division.
family division. So where do they go?
They go to the Department of Mental Health they are placed, ordered by the court into the custody of the Department of Mental Health. And they
So
could
they're
be,
under state custody.
yes, it could be an order of hospitalization. They're having enough care that they need that sort of acute level of care, then they could be hospitalized. Could potentially be an order of non-hospitalization, an ONH. They could be getting treatment in the community. And as well, the person can, depending on their clinical needs, they could move from one setting to another while they're in DMH custody. In other words, it could be under hospitalization, could be clinically decided that they're not in need of hospitalization anymore. So then they could be moved to treatment in a community setting or on an order of non-hospitalization. That could all happen while the person is under DMH custody. And again, that person never had any contact with the criminal justice system.
So if it's a order of hospitalization and they're under state custody, the civil, are they automatically housed at our state hospital in Berlin? Or are beds that we pay for down at the Brattleboro Retreat or the Rutland Hospital, where are they housed in the state-run facility or a facility that is run on behalf of this, somewhere else on behalf of the state?
That's another one of those questions about what happens when the person's in custody that I'm not sure the answer to, but I bet you could get an answer.
Yes, Claire Neal, Senior Policy Advisor for DMH. If a person is hospitalized,
Can you speak
Can
up?
you speak up a little
yeah,
bit, please?
absolutely. If a person is hospitalized involuntarily, they would receive care at one of our designated hospitals. So that's 6 hospitals across the state. It does include VPCH, but it also includes private hospitals that have been designated to provide involuntary care. Sorry, was there another question? I think
Well, you're at the state hospital in Berlin.
you can be.
You go, because this is new to folks here, so they don't know the beds out there for mental health. We have 25 beds in Berlin State Hospital. We have 14 beds at the retreat. Is it around 14?
Adults, yeah. Adult, yes.
Adult, yeah, I'm not getting into kids, that's enough. Adult, 14 at the Brattleboro Retreat. Those beds were built to replace when we lost the state hospital in Irene. And then we had 6 beds in Rutland.
Had or have?
We still do. It was all part of replacing the state hospital.
Okay.
So if you add that all up, 45 beds, you add that all up.
It's more than, I think.
Right, but to replace the state hospital, I'm thinking to replace the state hospital, and then the secure residential kicks into that too, but I don't wanna go there. But when we replaced the state hospital, those were the three big pieces to replace the state we lost. So then on top of that, what other designated hospitals would hold court-ordered folks for hospitalization? You know, you're thinking, sending out an email.
I'm just pulling it up. Sorry, I wasn't planning to testify.
When it's appropriate, could I give you a real life scenario and ask you to walk through what the process would be?
Yeah, give it a try.
An individual attempts to commit suicide twice, one with pills, one with alcohol. Still living at home. Third attempt, he runs his car off the road. He had been drinking, but he verbally says he did it to kill himself. He needed to be taken to Dartmouth Hospital because he was injured. His parents would like him to be helped, but he's voluntarily at Dartmouth Hospital being checked out for multiple days. They send him to Valley Vista. He doesn't like it there. And now he's released. I would say it's pretty obvious that he's a danger to himself. Frankly, he's a danger to his mother because of the way he's communicated to her. When, how is an individual treated in that situation as an adult?
How old's the person?
24.
They're an adult.
Do you mean like when does it become involuntary or
I'm just
potentially?
trying to understand the system. I mean, right now it's volunteer, but
It's not voluntary. They have to go through the court.
I know, I understand, but he hasn't gone through the court. What, how do you get him so that he goes before someone who's empowered to determine whether he is a forensic situation or not? How do you get to that point?
You'd have to have somebody, it could be a family member currently, or a medical professional, file a petition in the family division of the Superior Court.
Okay.
Even prior to that, there's also depending on how close that situation is to, in other words, let's say a law enforcement officer was involved really at the moment while the person was attempting suicide. That there also, law enforcement has an ability to put a hold on somebody immediately, very short term, and get them into custody and get them what's I think it's called an initial evaluation. There's a very short term, first time psychiatric evaluation to determine if the person, that has to be done within 72 hours, and make a first determination as to whether the person, even whether there's probable cause to think that the person might be a danger to themselves or others. In other words, before the court has made the final decision. But there is that avenue, but someone is going to have to
Petition.
yes, but it's also possible in that very life-threatening, sort of dangerous situation, there is an ability of them to be taken into custody by law enforcement and get them into custody right away, provided that they can get a psychiatric evaluation very quickly. And so, in other words, you don't have to wait in all circumstances for the first open court day, is what I'm saying. Right? There's that in an emergency situation. There's also an avenue. But yes, one way or another.
Because the law officer saw the activity of the individual.
Or it could be,
And deemed it.
or potentially a family member saw it and called law enforcement and, was able
Law
to,
enforcement.
yeah, but yeah, somehow they were.
So family can petition or law enforcement can observe activity that.
But even after the law enforcement officer observes or is contacted, somebody's going to have to file that petition
Okay.
with the court, because if you're going to continue to hold the person, it's all a very substantial deprivation of somebody's liberty, which is a constitutional issue. So that's why you have to have very specific court procedures to make sure that there's evidence to be able to hold somebody. Otherwise, you're depriving somebody of liberty without due process of law. Yeah.
Petition, someone has. to-
Yes. They do. Yeah.
So you had the answer for outside, what other hospitals would be designated to hold?
Yes, so it's UVM
Did you speak up?
UVMNC, the Brattleboro Retreat, VPCH, Vermont Psychiatric Care Hospital, Rutland Regional Medical Center, Wyndham Center, and the VA. There are 167 total beds for adults
Statewide.
statewide.
You know what our current occupancy is?
This is from, in February, 156 were occupied, but I can get more.
Oh, that's great. Thank you.
So someone has gone through a situation, they've gone through the court. And this, I think, is gonna get more into Katie Simon's lane, but
Yep.
they've been petitioned, court's been petitioned to hold someone. Or not hold, but to receive services. And the court deems that the person really needs to be hospitalized. So let's say they go to our state hospital. Okay. They are there involuntarily, they are under state custody. And then what happens? And I know this is probably beyond your lane.
It is. But I did, this may be going a little bit further down the timeline than what you're thinking, but it is also going to be relevant when we get to the forensic lane, the criminal justice lane, because I happened to speak, I gave Karen a quick call, like phone a friend before I came at lunchtime, like, I don't know, that's right.
Yeah.
Right, so, so Karen told me a little bit about, because I was curious about, what's the perceived gap that the forensic facility bill is trying to fill. And one of the things that she indicated to me is because, as you're mentioning, Chairman, after the person's been treated for a while, well, what happens if the person, it's determined that the person perhaps is not dangerous to others anymore, or they aren't at what is Karen described at least as needing an acute level of care. And that's a clinical medical determination. And there's a connection between that and the ability of the facility to get Medicare and Medicaid dollars. So that if it is clinically determined that the person no longer needs this acute level of care, then they can't stay in the hospital setting anymore.
They lose the Medicare or they lose Medicaid.
I'm not sure.
So all of our hospitals are Joint Commission accredited and CMS certified, and the CMS certification is based on the appropriate clinical placement. So it is Medicaid, and it would not just be for the individual, but the hospital could lose its certifications as well.
Those Medicaid payments to the hospital.
Which is less of an issue with this group of people that we started talking about, people that have never been involved in criminal justice system. They came in through the civil system, and it doesn't raise the same issues if the hospital is making clinical decisions about, well, this person doesn't need treatment anymore, so we can just release them to a lower level of care. Maybe they don't need care as much at all anymore. Not to say that that's not important, but just to say that it doesn't raise the same issues as if that same person had committed a homicide and had been found not guilty by reason of insanity. If that's the situation, and then the hospitals clinically determines that the person doesn't need an acute level of care anymore and can't be in the hospital anymore, needs to be stepped down somewhere, raises different questions, because at that point in time, where does that person go? Particularly if they might still pose some level of dangerousness. But remember, it's resting on the fact that it's because of a mental illness. And someone can be not guilty by reason of insanity or incompetent to stand trial for reasons other than a mental illness. So that is part of the gap that's proposing to be filled by forensic facility legislation. They can treat people they would treat people who are either incompetent to stand trial or not guilty of everything insanity for reasons other than a mental illness. Right now, those folks, because of the definition of person in need of treatment that I mentioned, that's based on a mental illness, because of that, they wouldn't be eligible for that DMH hospitalization.
Mary, do you want to weigh in?
Well, I'm very aware of a case where, and forgive me, I'm losing now my voice. Thank you, teammates. Anyway, of a case where a young man, some very threatening behavior to neighbors and other people. He was determined that he needed to be evaluated. He was evaluated and I think was kept for a couple of weeks to possibly get some care or whatever. Then was determined that I guess he was all okay. Goes back into the community, threatens his family members. I mean, really threatens. And I know there were some criminal kind of charges from that, but nothing ever happened. So how do you get, and then ultimately he was let out again. I think he was there for a very short time. Again, hospitalized, was let go, and then murdered someone.
Mhm.
So how do you try to, I know you're looking at their liberties, their personal liberties and not overstepping, but when does it become public safety, and how do you, safety for him, but safety for public, his family, everyone. How does that happen? And right now, I think he's in a somewhat of a hospital type situation, and they aren't really looking to go forward. They can't go forward with the case, and so it's kind of just in limbo. There's nowhere really to put it. So you don't know if where he is, right, to others there. So how do you kind of get your arms, or the system gets its arms around safeguarding for folks without, again, I know his personal liberties, you don't want to overstep either, but there's a real fine line there.
True, it's a difficult balance, but you're right. That system is trying to balance both public safety, community safety with person's liberty interests. And at least legally speaking, the way that that has kind of resolved itself is to require that a person in that situation can be confined against their will, as long as the court finds that there's what's known as clear and convincing evidence that they're a danger to themselves or others. So in other words, that's not,
Pretty high standard.
it is, it's not as high as beyond a reasonable doubt. So that's kind of where they've set it.
And
Sure.
can the person decide he doesn't want to be evaluated? Because I know there was the question within this case that he didn't really want to go forward, so it's just kind of hanging out there, shall we say, and it's not going in any direction. So and again, the forensic facility in part was brought up at the time this all kind of started. And I was involved with it as well. That was why it was, so that you would have a safeguard place for folks who are really struggling. And, also the public safety side of it. And it's a very difficult.
That's what we're going to be grappling.
So.
Yeah.
Let me try. So a family chooses to petition,
Mhm.
and the person is an adult,
Right?
person who is we're concerned about, refuses to cooperate. So if they're not willing to go before the court for evaluation, do they have to commit a crime before?
But the family will go before the court,
Understand, but they petition,
right? The family
but
goes.
the adult says, I'm not gonna participate.
But
I'm
that's
not gonna
not,
be evaluated.
but that's not so easy. I'll tell you another story I'm involved with recently right now for a constituent. The courts had asked for this particular person to be evaluated. He's still out in the public. Things have ramped up. He's been arrested numerous times. He's now off his meds on all kinds of substances to fulfill that need.
Right.
He's threatened and physically has done some harm to some family members. I mean, it just keeps snowballing bigger and bigger. And what do? I mean, I was just on the phone this morning with several different agencies to see if folks can connect the dots to even where do you keep him safe and where do you keep the public safety again? So it's not an easy, simple, and the courts are kind of struggling because they filed a petition, I think, or filed something, but the other agencies aren't looking at it either. So it's
So Eric, in a situation where a family member has petitioned the court, the civil piece, and petition the court, it's the court that determines where the person, what then happens to that person. Do they need the person actually in front of them at the court to make that determination?
I don't think so. I don't think so. I think it all depends on what other evidence is presented and that the evidence of their mental illness because remember, it requires danger to self or others as a result of a mental illness that can be presented clinically by medical professions.
So if the court orders that the person needs to be clinically evaluated and housed within one of our beds, how does that person then get there? Do they depend on family members to bring them there? Or how does that transaction work? And that may be a question more for DMH than you. But
In some situations, the person might already be in custody, because as I mentioned, law enforcement has the authority to, in an emergency situation, to arrest somebody right away. I should say it's not technically an arrest because there's no probable cause of a crime. Right. Yeah, exactly. But place someone in custody. It's a better way to put it. So they may be in custody already. But if they're not, then I'm not certain. It's an involuntary order. So if the person refuses, presumably there is the authority of the law enforcement officer or somebody to place them in custody because they're not depending upon the person to agree.
That lines up with my personal story. I was desperate for my son in Connecticut and calling everyone I could. He can't do anything. He's an adult.
That's
Breaks the law.
Connecticut. That's
Well, I
Connecticut.
understand.
So
I
they-
understand. That's why I'm trying to understand what Vermont is.
Right, but they could have a whole different law.
I understand. So I'm trying to understand Vermont, but until they break the law and they don't want to participate, how do we help them? That's my question to you
Right.
currently.
Yeah. Well, again, the civil order doesn't require illegal conduct. It's danger to self or others. So that person can be placed in custody, and a court could find that the person could be ordered subject to involuntary inpatient psychiatric treatment on the basis of them being a clear and convincing evidence of them being a danger to themselves or others. Doesn't require that they've committed a crime.
I'm happy to hear that.
Yep, that's true. Now, again, that is, as the chair was saying, that's moderately challenging evidentiary threshold to meet. But that's the balance that you're talking about. That yes, we're going to permit someone to be involuntarily confined at times, even though they haven't committed a crime, because that's part of the reason for this. If the person's committed a crime, we'll get to next. Remember, there's already been an allegation that they've engaged in illegal conduct, and in some cases, clear and convincing or beyond a reasonable doubt evidence. This situation, no crime. But so, just to give everyone a refresher of the three general levels of proof, beyond a reasonable doubt is in criminal cases, right? If no reasonable mind would find anything else other than that. That's the highest. The lowest in most civil cases is called preponderance of the evidence. That just means more likely than not. And just to be means a degree of evidence that, while not sufficient to free the mind wholly from all reasonable doubt, is still more convincing than the opposing evidence and is sufficient to incline a fair and impartial mind to one side of the issue rather than the other. That's preponderance. That's the lowest. The middle one, though, the one that applies here, which is, let's say you do have this person who's presenting a danger to themselves or others, haven't been convicted of any crime. What does the court have to find? What does the state have to show? Clear and convincing evidence, which means evidence indicating that the thing to be proved is highly probable or reasonably certain. So more than preponderance, not beyond a reasonable doubt. And that's it's a balance between you're depriving someone of their liberty against their will, but you also have public safety to be concerned about. How do you balance that? So the way you do it, the way it has been decided, is that we're going to require some substantial level of evidence before a person can be involuntarily confined, assuming they haven't committed a crime.
So that's on the civil side. So
Right.
let's shift over to the criminal side.
Right.
So say a person is charged, they're brought in, they're charged with a crime, whatever it may be. And at the arraignment, the court wants a evaluation, mental health evaluation. Doesn't mean about maybe competency to stand trial or insane at the time of the crime. They also just ask at times for a evaluation, or is it always an evaluation for competency or insanity at the time of the crime?
The most that I've heard is when someone raises the issue of competency, or when the defendant indicates that they're going to raise an insanity defense. Any party, the prosecutor, the defense, the court, anybody can raise competency at any time. And that's because competency is it's a threshold issue. You can't be tried for a crime if you're incompetent. And to do so would be unconstitutional. So that if anybody becomes thinks that there's reason to believe that the person's not competent, they have to bring it up. So that's when I've most heard that the evaluations take place.
So right now, someone's being arraigned and one side or the other raises the issue, let's say competence.
Mhm.
The court orders an evaluation to determine competency.
Right.
Where does that person go right now for that evaluation?
I know that, at least from the statute, that it can be the state hospital, right? But I don't know necessarily that it has to be.
Could be a non-hospitalization
I think so.
order. So there could be a hospitalization order. There could be a non-hospital order to determine, I'm just going to say competency.
Right.
So if it's a hospitalization order, would they automatically go to one of our state hospital beds, be it in Berlin or Rutland or the Retreat? Or would it go to someplace like a Wyndham Center? Or would it be more our state hospital in the Retreat?
It could be any designated hospital based on their clinical need. VPCH and Rutland provide level 1 care, which is a different staffing pattern, or more intensive staffing pattern.
Day 2 care.
But other than that, if somebody's on a hospitalization, they can be served at any designated hospital.
For the evaluation.
Yes, but they don't have to be in the hospital. They don't have to be in the hospital to be evaluated, like they could be evaluated.
Wouldn't that be more of a non-hospital? It sounds so good.
Eric, you may want.
That would have to be a non-hospitalization order, but if they had a hospitalization order, they would have to be in a hospital, right?
Yes, they could be evaluated while receiving
It's
inpatient.
one of those. And then once that evaluation is done at the hospital, the hospital, where does the person then go? Do they go back to court? Where do they go? Do they stay at the hospital? They've been charged. But there was a defense raised, or maybe the judge was concerned, this doesn't feel right to me. I want to have a mental health, but competent, and evaluation.
Well, that can depend, where they are physically, if that's what you mean, can depend on the nature of the criminal case. You know, it could be that if they were charged with a homicide or another offense that was punishable by life in prison, or then they might be actually being held in a correctional facility while this is going on.
How the evaluation.
Yes, absolutely. On the other hand, if it was more of a situation where it's, you know, a low-level property crime where we know that these things do happen also by people who aren't necessarily competent to stand trial, in that sort of situation, person can't be held without bail. Chances are they go back to the community.
I mean, I think it's still your line of questioning, but yeah, does the way the evaluation is done depend on where the person is? And just to use your example, if somebody has committed a homicide, they're housed in DOC, are the same folks who would be doing that evaluation in a hospital doing it in DOC, or is that then going to be WellPath or whoever the provider is in DOC?
Another question, that's a good question that I don't know the answer to, but.
Sorry, I keep getting out of my way.
Yeah, Claire Neal, Senior Advisor for DMH. So DMH has a contract with a third-party provider for competency evaluations. It's determined by the court. But a competency evaluation is only a legal evaluation. It doesn't provide any kind of diagnosis or treatment recommendation or really any clinical recommendations for a course of treatment or anything like that. It's just the legal determination of are you competent or are you incompetent?
And yeah, and you said outside, so that like unaffiliated in a way, and would be the same folks doing this wherever the person was.
Yes, there's
Yeah.
there's a third party in Novotel that provides these for contract with DMH person.
Okay, thanks.
So say it's a property crime,
Mhm.
okay? And the court has ordered an evaluation. They go to, let's just say the state hospital for simplicity. They're evaluated over time and then it's determined that they're competent.
They are coming.
They are competent. So who determines and where they go next? Is it DMH that determines where they go next? The person had to go back to court, because this usually happens at arraignment, just doing something real simple at arraignment.
Well, I think if the court, if there's a finding after the evaluation that the person is competent to stand trial, then that was the finding of whoever the third party was, the contractor, whoever else that made that decision. And that means the criminal trial can proceed, and where they are is dependent upon, I'm going to presume, low-level property crime. There was no bail, or rather they can't be held without bail. So maybe they paid their bail and they'd be wherever they were. There wouldn't be any restrictions necessarily on their whereabouts.
So it really depends what happens at the court on that arraignment. What the court could put on conditions for the
Right.
person. Then they would have to comply with that, but it would be DMH that would determine if they were at the state hospital. There'd be a third party or staff at DMH that would do the evaluation. And they would determine this person over time, this person's now competent to stand trial. And then mental health would determine to release the person from the state hospital. Is that correct?
They would be unrelated decisions. So the third party would do an evaluation to determine competency or incompetency. Separately, the care provider would do a medical evaluation to determine where the best clinical placement was, but they don't inform each other.
So it would be a clinical placement after that? Would they ever be just released back to the community
They could be if they don't qualify for a placement, yes.
if they don't qualify for a clinical placement? And then if they were released back to the community, then they still have to go back to the court because they've had conditions on their release like everyone else. Then they would have to go back to the court at a later date for their sentence or trial or whatever.
If, as you said, in that hypothetical, the finding that was that they were competent to stand trial, then yes, criminal proceedings would continue.
So if there was a major crime and say that, bail was set and the person needed to be evaluated for competency, they were held in a correctional facility because there was bail imposed and it was a serious crime. So they end up being a detainee.
Mhm.
Third party does an evaluation. Is there any, after that, any clinical determination where the person should be housed? Or is it the criminal charge and the detainee being held with bail? Is that what is the decision versus a clinical decision of where the person is housed?
I wouldn't think that the clinical decision, if the person is found competent to stand trial, then I don't think there's any reason for there to be, the person isn't going to be held by DMH anymore, as far as I know. Because they're not, it's not been determined that the person needs treatment, right? That's
But they could, if they're a detainee, they're being held
a DOC,
by DOC.
right?
Bail had been imposed and they hadn't met bail. So even if they are then deemed competent at some
Right.
point,
Right?
they would stay incarcerated as a detainee unless they made bail.
Right. So the sort of usual rules related to bail and whether or not they're detained or not would continue to apply. And the person would then move along toward trial,
And becoming competent
Finding a-
along the way.
right? That's always possible.
That's possible. Works.
And maybe you've already said it, but if he's determined, he or she's determined to be incompetent, but he murdered a person, where do they reside?
Allegedly.
Allegedly. Well, if they, yeah, I mean, if they know,
That's gonna be
you
important,
still gotta go through the court, right? Even if they saw it happen.
not if they're incompetent.
That's my question. So if they're found to be incompetent, but they did the crime,
Mhm.
where are they housed?
So that, in a way, is a nice segue because we were just talking about what if the finding was competent, right? We sort of went through that a little bit. Let's say, as you described, finding instead was, in other words, they can't understand the charges against them or unable to participate in the defense. So this evaluation that you mentioned comes back with a finding of incompetence. What happens then? Then the court has to have a hearing. And at this hearing, the question is, same question, this is where it starts to become clear what the proposal is for the forensic facility, because right now, this is under existing law, right? That we're talking about what would happen. The person has to be determined whether or not they are a person in need of treatment. Same definition that was used in that civil context. Remember the person that comes, a family member or a doctor. Same issue. Is the person, as a result of a mental illness, a danger to themselves or others? And if the answer to that question is yes, then they get committed to the Department of Mental Health for the same kind of treatment that we were just talking about. Could be an order of hospitalization for treatment in a hospital, could be an ONH for treatment that's not necessarily in a hospital setting. But that is the question, is are they a danger to themselves or others as a result of a mental illness? And that's a finding that, a hearing that the court is required to have after a finding that they're either not competent to stand trial or not guilty by reason of insanity. That next hearing has to happen. And the difference too is that hearing in this case is in the criminal division. Remember, in the other setting, with respect to civil folks, that hearing's in the family division. This is a criminal division. But it's the same legal question. Are they, as a result of mental illness, danger to themselves or others? So, because the person treatment definition depends upon mental illness, that means because there are other reasons that a person might not be competent to stand trial. It's not just mental illness. It could be a drug addiction. It could be traumatic brain injury. could be a number of other things that could cause a person to be unable to understand the nature of the criminal proceedings. So that is what is being described as a gap in the current system, because that person could be incompetent, but if it's not based on a mental illness, then there isn't necessarily a basis to have that person committed to Department of Mental Health custody. So, as you will see, when you look in more detail at the forensic facility bill, that allows commitment to the custody of Department of Corrections for any reason that they were found incompetent to stand trial. Or I shouldn't say any reason, any other, it's called a qualifying condition, but any other mental health condition that might have caused that.
So it still would be a mental health condition. Or not.
You're kind of getting into the clinical, which is a little outside me. Let's see what the terminology is, just so I don't get it totally
This
wrong.
is beyond, this is not your lane. You want to weigh in?
So it wouldn't necessarily be a mental health condition as defined by DMH coming within our jurisdiction. If we talk about mental, that help with the brain generally, then I guess it could qualify, but not how we speak about mental health or mental illness. In terms of our unit's jurisdiction. It can be broader than that. As Eric said, it can include TBI, dementia, substance use, and we do see regularly reasons other than mental illness for people to be found incompetent.
Why not? It's a little, well, just to read the language at least, because it's just, why not? That way it'll be familiar when you go do the walkthrough next week, right? But, so qualifying condition is what is the term of art that's being defined. And it's defined as any condition, whether mental, congenital, or traumatic, however acquired or developed, or any other circumstance that resulted in the person being determined incompetent to stand trial or not guilty by reason of insanity. So not just a mental illness. And the idea is, as I said, to provide a place where a person can be determined who's been found incompetent to stand trial for a reason other than a mental illness, which.
So right now,
Yeah.
where would the person be detained?
Yeah.
Would they be still detained in an incarcerated setting because they're being charged with a criminal act? Or would they be released back into the community?
My understanding,
Or would they be at the hospital, state hospital?
that could be, I have heard that some of them still remain in DOC custody. There are still some of those folks who are in DOC who, because of the way the system is now, aren't subject to DMH custody. But nevertheless, have still been found incompetent. So they can't be tried, right? Because they're incompetent. That's
So
what,
you've got a person that maybe didn't kill someone, but seriously harmed someone. And the person has Alzheimer's. Is that person going to be housed in a correctional facility? 70-year-old person,
I think it's possible.
somebody with a traumatic brain injury as a result of a car accident. It may have happened a long time ago and acted out a real criminal. Isn't competent because of the TBI.
I think, I'll double check this, but there's also a group of folks who can conceivably be placed into Dale custody. And TBI may be one of those.
Alzheimer's?
Oh, no, I thought you said TBI.
Well, I did say TBI.
Oh, right.
Alzheimer's.
Oh, I don't think so. Right.
What was the facility?
Dale, the Department of, I think it's Dale. Maybe
Department
it's,
of Aging and Independent
Living.
Living, another department.
I think it's them who have custody of,
Jail.
I think that's correct,
yeah,
based on my.
right.
Fine. Well,
It's all, I mean, I don't know, I'm probably, everything that we're talking about is the intersection of law and medicine, right? So forgive me if I'm out of my lane again, but there are two questions. One is, I guess I should do them separately. We've been talking about it, but is there an accepted legal or even statutory definition of mental illness? Yes.
Depends what world you're dealing with. If you're dealing in corrections, there is a specific definition of seriously functionally impaired. Encompasses,
Right.
and then out in the community,
Yeah.
there's a different definition.
Yeah. I guess I could park that one. And then the other
That's the
one.
Katie McLean
Yeah.
question.
And then the other one is about the facility itself. For a forensic facility, is it defined as a place whose job is to make someone competent? Or is its definition more expansive?
It is more, it actually, yes to both.
Yeah.
Because the function is different depending on whether it's a person who's been committed there because of incompetency to stand trial, or a person who's been committed there because of not guilty by reason of insanity. With respect to the first group, who's been sent there because of they've been found incompetent, then yes, their function is, at least in large part, to provide competency restoration services throughout the person's commitment there. But a person who's been found not guilty by reason of insanity, that person isn't going to be restored to competency. They're found incompetent, and they cannot change the fact that they were found not guilty of the conduct at the time that it happened. So there's not a restoration piece that's involved in that person's treatment. That group of people, that group is treated differently. And so I guess it depends on the group you're talking about, right?
So right now, for a person who is in GRI, not guilty, reason of insanity, what then happens to that person right now?
Same thing, same hearing I just described. Because there's been finding of NGRI, then they immediately move to the hearing. Same thing with the incompetency. As soon as that happens, go to the hearing in the criminal court. And the hearing is that same question. Are they a danger to themselves or others as a result of a mental illness? Again, person in need of treatment. That's what the way to term it, that's what it means. And if the court finds that, yes, the person is a danger to themselves or others on account of the mental illness, then that person also gets committed to DMH custody. Can be in the hospital.
For a long, long time,
Yes.
because there was a situation back in the 80s of shooting in a battery plant.
Yes, in Bennington.
Already.
Another story.
Yeah, and I believe the person was deemed and GRI,
Right.
and she was at our state hospital.
Years.
I don't know, she's still under DMH. So she was at the state hospital. This happened back in the 80s, was it the 80s, early 90s?
It was early, late, it might have been 89.
Yeah, and as far as I know, she's still under DMH. So she was at the state hospital. I know when we lost the state hospital during Irene, she had to be placed somewhere. And then I know when we finally built the secure residential, I heard she was placed there for a while, and I don't know after that where, but at least she stabilized so that she could be in a least restrictive environment for that. But that's what was out there in terms of information. It's all private information too. But that has happened. There are folks who are not guilty, who's been insane at the time of the crime. It's a very high standard. It's very few that are successful in using their defense.
Yes, I think
Very
as it happened, it came up this morning in Senate Judiciary, not with respect to this bill. It's interesting, some very similar concepts are being discussed. And I can't remember, maybe this committee remembers, they're also in connection with the 8606, firearms bill that came out of House Judiciary and House for last week, maybe? Yeah.
2 weeks ago.
Yeah, involves some of these same concepts because there was a prohibited language in there based on someone's mental health history and involved the exact same ideas of competency to stand trial, not guilty by reason of insanity. Anyway, so that bill happened to be being discussed in the Senate Judiciary this morning. And Defender General Valerio mentioned what you were just saying, Chair Evans, which is that he surveyed his state defense attorneys. Very, very rare. It's that the NGRI, far more common is the competency to stand trial issue. But you'll see that in the bill, the possibility that someone who's found NGRI will be detained at the forensic facility for a long period of time is still there. It's still possible because there has to be a determination. You'll see that the forensic facility has what's called a clinical services director. You'll see that in the bill. And that clinical services director determines that the person's release would still cause a substantial threat of harm to somebody, then they would still be detained. So it's still possible that the person would be there for a period of time. But if not, then they can be released on conditions.
Who would set those conditions? Because they're under, they're in a correctional facility, so thereby, are they under dual custody with DOC and DMH?
No.
Just DMH?
Yeah. No, just DOC.
Just DOC, so. I just love it. Let's throw it at DOC and increase their budget. That's what's gonna happen.
Yeah, but also can they
Oh,
determine?
yeah, because they're gonna hire staff. they're
Yeah.
gonna have
But also,
corrections.
but also do they have the qualified staff to determine who is mentally competent or not? And again, I'm not trying to,
Where's the
find any
space for
whatever,
displays?
but-
You're not gonna mix populations here. Maybe. You may not be able to mix populations either, or you might.
Space for what they have now.
And this is what we're gonna have to deal with, because if you read the bill, there's gonna have to be, if this goes through, there's gonna have to be some physical changes to one of these facilities. And that's not being calculated in the BGX to do. And you're gonna have a different qualifications for staff. And is that staff gonna be part of WellPath?
I think WellPath testified down in Senate Judiciary that this is the kind of thing that they do in some other states, and they would be prepared to do it under the
So
system.
there goes your increase in WellPath contract. And then who does WellPath answer to if they want to release someone? Saying, they'd be okay.
Business grows.
Claire, they have to talk to Claire.
No, Claire's not involved with WellPath.
Say, no, we don't do
They're
it.
involved with DOC.
Right.
So this really shifts it from the mental health world to the corrections.
Yes, I think that's part of the intent. And it is true, there's language in it that requires DOC to do all this sort of in consultation with DMH. I found somebody else here, maybe it's just DMH. But in any event, final, it's DOC, it's the managing. It's just, I don't know. But in any event, yes, it's the lead role is corrections.
So how would this tie in? If they're gonna be in a correctional facility and under the custody of corrections, how does this tie in with our definitions of SFI? And how SFI, seriously functionally impaired? How does that play into that? And what DOC can do in terms of segregation or classification of that person? How does that play in with current statute? We have an SFI statute,
Right.
right? I mean, we spent a lot of time in here. for that. We also have statute that pertains around services for folks with mental health issues that DOC and DMH need to work together here. So how does this play into all of that? I don't know if anyone in judiciary over in the Senate looked at any of that.
I'm not aware of that coming up. But interesting question. And, would DOC view this population as still subject to those standards?
And procedures and directives within
Right.
their department policies.
Yeah.
I mean, that's where it overlays. There's a lot of complexity to this. Not just housing someone with mental health issues and maybe deemed incompetent that's not housed in our mental health system, but is housed now in the correctional system. And I'm assuming this is just for folks who have been charged with a criminal activity.
Yes, exactly. That whole civil group that we talked about at the beginning does not go to the forensic facility. Only people that are coming from the criminal courts.
Right.
Same caveat about law and medicine, but so if we're talking about someone who has come through the court, some sort of serious crime, is the placement of this person in the facility, I'm not sure which of you this is a question for, is it based solely on their medical needs, or is there a distinction about where this person will be placed based on whether we're looking at them being deemed incompetent or deemed not guilty by reason of insanity? Does that affect where they go under the current setup?
You mean under the current setup, not the bill?
Correct.
But
Yeah, like what's happening right now in Vermont?
I would say that right now, that's going to be a question for the department, because from my perspective, as I mentioned, the initial legal question is, once the person has been determined NGRI or incompetent to stand trial, then the court has that hearing to determine whether or not they're a danger to themselves or others. If the answer is yes, then they go to DMH, and then how the determination is made, whether they should be hospitalized or ONH or whatever. I think that falls into DMH's expertise at that point.
And before the person has been deemed one or the other of these things, where are they? Are they being housed currently, before they've been deemed competent or incompetent, before they've been deemed?
Oh, that could all depend on whether or not, I think, was it a serious offense? Might they be being held without bail? That's entirely possible. So they could be in a corrections facility already. Was it a very minor offense and that they weren't being held? It could be that they were, in the community. It's some very minor property offense, for example, something like that. That would really turn on the nature of the criminal conduct they were charged with, where they were status-wise, up until the point that.
So until one of those judgments has been made, I guess the question of the medical question, in a sense, doesn't enter into it. They're housed at home or in society or whatever, or in a correctional facility based on the severity of what they're doing, as opposed to anything to do with their mental health.
Well, it is also possible that if there was indications that the person was dangerous earlier on in the timeline, right? I think it probably would be possible, although I suppose if that happened, it would still be probably in DOC custody one way or another. Absent some finding by the court that they were a danger, then they're still, I think, subject to DOC.
Okay.
But even those who are held without bail have to have a trial. I mean, I know there's a backlog within 60 days, so there's a 60-day limit on those holds.
Right.
It's not happening right now.
I know, but you're right, it does exist. Yeah.
We've got a lot of work ahead of us on this.
It's a lengthy, complicated bill, true. Yeah.
This is the first exposure we've had, and I'm sure a lot of the same questions are going to come up as we start thinking about this a little more, start understanding it. It's going to be a heavy lift, and it's going to be an emotional lift. There's gonna be a lot of divergent thinking in this body, not just this room, not just judiciary room or human services. It's going to be a big issue for the House in general. I think it's gonna play out a little different here than it did in the Senate. Maybe not. I don't know.
It's good, you're right.
The part we leave up to you guys.
Yeah, all right.
I think you should come to us on the 17th with a finished product.
Oh, yeah. So,
So.
we'll try though. We'll do our best.
So the bill has passed the Senate,
Yeah.
correct?
Yes.
So it will be over here probably Tuesday or Wednesday next week. So at least Martin and I need to have a conversation. Where does the bill physically go first? Doesn't mean that wherever it goes first, that's gonna be the committee and only the committee that works on it. It
Right.
goes to the judiciary first. We'll be working on the pieces that deal with corrections. There's a lot of corrections in there. If you haven't read the calendar, Senate calendar, and that's right there. It's been posted on our webpage. What you sent or what was posted for S-193, is that how it passed the Senate or is that just the center lines amendment? Looks like just center lines.
That was just the Lions piece, so it was not. I haven't actually seen, because there's a process that our office goes through to integrate everything, and I know that I just finished the miscellaneous procedure judiciary bill, and I guess now that I think of it, no, that's probably why, right, because it just passed yesterday, so, because I haven't seen this one, so that means that the final integrated version isn't on our website, it isn't here yet, but hopefully, it's today, Thursday, maybe tomorrow.
Next Tuesday, by the time we see.
Not making light of the situation.
Yeah.
How would one petition the court? Do you retain a lawyer and have them help you put the petition in, or do you go online and start filling out forms? How does that work?
Either one, yeah, you don't, it's not required, you can proceed what's called pro se, means without an attorney, you could do that. I would contact, let's just say hypothetically, we're talking about the family division for one of these kind of situations that you were talking about. I would call the court clerk of the family division, in whatever county you resided in, and I would say, here's what I'm thinking about. How would I find the petition to fill out? And I'm 99% sure that court clerk would say, I'll send you the link, or here's where it is on our website. You can fill it out. I think obviously you could retain an attorney, not that you couldn't, but I don't think you necessarily have to. Yeah, it's my thought.
Any experience as to how quickly those petitions are reviewed?
Again, I think if it's I don't have personal knowledge. Generally speaking, when it's a situation like this, when it's an emergency healthcare situation, courts try to move quickly and move those things to the front of the line. I think they do their best, knowing that, like everybody, there's a long line, but they do their best with that kind of stuff.
Anything else? Questions, thoughts? So we'll have our work cut out on this. We'll have to bring in a lot of people to testify.
Yes, you want to hear from plenty of people.
We do have the background in here at DOC. And we do have the background of BGS. And that's gonna be a lot of the load on this particular bill. The logistics, and I'd be also really curious what we have in statute right now, DOC with mental health issues and SFI. So that's gonna play in.
Yeah, that'd be an interesting question for them. How do you see that?
Senator Sears was here, he would have brought.
Yeah, you probably would have, right?
Let's see what that, because we were in the throes of putting all that together. So we'll have you back, Eric. We'll
Yes.
schedule Katie once the bill gets done and walk through, and we know, regardless which committee it starts in, we'll still be working on
Sounds good. Well, any other questions, let me know. I'm sure we'll see you back on the bill again soon.
it. I hope nobody's coughing.
So many.
Right.
Thank you.
All right, thank you all.
Karen?
It's okay. Karen is the best person to speak on this.
Yes, Karen, I've seen her a few times. When you said Karen, I was like, oh,
He's on a plane today, but I can.
Oh, really? Wow, she answered that's what, when I said I spoke to Karen, I did mean Karen. Sorry, I looked at you, so you probably thought I would, but she answered the phone at noon, so maybe she was right in the airport or something.